Good morning.
Good morning. May it please the Court, William Harrington for the defendant, Jose Escalera. I'd like to first just jump ahead to my fourth argument and state that, at the very least, I'm asking that this Court grant my client a new trial with respect to all counts or convictions except the one ammunition, and that's based on...
The Commonwealth makes that concession, doesn't it?
Yes, and that's... So I'll move on. I'll just ask that this Court adopt the appeals court reasoning on that ground. With respect to my other arguments, and these arguments I'm really seeking essentially dismissal of the evidence or the claims. My first argument is that there was no probable cause for the search warrant to search my client's residence. I will concede that there was probable cause to infer that my client was engaged in a so-called drug delivery type activity. However, that there was not any evidence linking that activity with my client's residence to conclude that there was probable cause that they would find either drugs or evidence of drug activity at his residence.
Would you take the position that the only location where drugs were likely to be found was in the cars that he drove? I mean, they observed him, right? They watched him. They set up meetings with him and watched him leave his house, get into his car, go to the drug place, drop the drugs off, then drive back to the house. So,
I would argue that given the observed conduct, and there was 4 controlled buys and there was 2 other incidents where they made observations of my client leaving and coming back. With respect to those 2 incidents, both times he accessed there's 2 vehicles here. He drove an Audi and he accessed a Toyota before he entered the building.
right.
Both times, both of those, one, he looked around furtively before, and not only did he enter the Toyota passenger compartment, but then opened up the hood and appeared to either take something from the motor compartment or put something there. That is very, very unusual, and I'd submit that it's affirmative evidence that he was using that vehicle as the base of his drug dealing operation. And that distinguishes this case from other cases I'm sure the Commonwealth will cite, that there's affirmative evidence, and it's very unusual. That typically doesn't happen. People don't look around and then open up the compartment and place something in their engine compartment.
Or remove something.
But Counsel, you're suggesting that he can only have one place. You're suggesting that even though there were 6 observations, 4 of which had him leaving, 2 of which with a CI, the other 2 in a pattern that was consistent with the CI observation leaving without accessing, returning and accessing, that he can't have maybe leaving it under the hood, leaving something under the hood, then going into the house, taking it from the house, and you can only have one place?
I don't think you can only have one place, but there's no evidence he had another place. And with respect to the observations of him leaving, of the 4 controlled buys, only 1 he was seen leaving, and that observation was described as driving out of the parking area. So the inference is that the police officer who was observing him did not see him leave the apartment building, and presumably is consistent with him having accessed a vehicle and then driving. So I would disagree with Your Honor that he was observed leaving 4 times. I think of the 4 controlled buys, there's only once, and he was only observed driving out of the parking area. With respect to the other 2, he was observed leaving the building, but each time he was, on those 2 instances, he accessed the Toyota before entering into the building. So with respect to...
Coming back, not going.
Yes.
That's different.
Yes. Coming back,
Right.
both times he accessed the Toyota before entering into the building.
But really I'm focusing on leaving, because that's when you need to have what you have. Don't you think
I
you should focus on
understand.
leaving?
I submit that one important aspect of this case is there's really no evidence that he was engaged in a large-scale drug operation. And I think there's some cases where they say they look at...
Large scale, I don't know what you mean by that. He was certainly engaged in a regular drug-related activity. I mean, maybe he wasn't selling kilos. Is that what you mean? He was just selling street size. But a phone number, call in, meet you here, meet you there, meet you here.
What I mean by that is the CI in this case really gave no indication of buying from him previously. Maybe you could infer that on one occasion. I think his statement was there's a person in Brockton who sells cocaine or heroin, I forget which, and it's a delivery service.
And it was pretty easy for him to arrange 4 buys in pretty quick fashion.
Yeah, there's no doubt, Your Honor. There were 4 controlled buys. Each of those are relatively...
Somebody that presumably didn't even know your client. That was pretty... You said there's no record of any prior history, so just call this number and 1, 2, 3, 4. I mean, that's evidence of a business.
What I'm pointing out is many affidavits will say that the CI will relate that he's been buying drugs for this period of time, this often, these quantities. This CI, there's no information as to that. So with respect to the 4 controlled buys, yes, there are 4 controlled buys within a week or so. The amounts of those sales are, I think, $40, $60, $100. They're relatively small amounts. There's someone consistent with someone who could store his stash in his motor vehicle or in the motor. It's consistent with that. And the lack of evidence of a large-scale operation, I would argue that there's less of an inference as to whether he would have records of this business. There's no indication that he was selling on credit, that he would need to have a ledger. This case, there's really no evidence that I know there's 4 controlled buys, but there's other cases with an affidavit that gives more information as to the extent of his business.
Is it relevant at all that your client told the confidential informant that he also owned a number of rifles and firearms and was interested in buying more? Does that suggest perhaps they might more likely be stored in the home? I mean, firearms and drug business go together?
Your Honor, I don't believe that the search warrant, and I could be wrong, my memory of the search warrant authorizes the search of drug evidence, equipment, proceeds. I don't believe there's any request in the search warrant for ammunition. And Your Honor, I haven't thought of that question, Your Honor.
But I think you're right as to that. But it does speak about other incidentals which relate to the business, such as packaging and papers. I mean, there's more than drugs that could be found. There could be the typical glassine bags. There could be scales. Those would not be routinely kept in a car. Why is it not appropriate once you establish that somebody appears to be in the retail, in the mom and pop retail business of selling drugs, to infer that there will be those incidentals of drug sales?
For one, I do believe you could store all that in a vehicle, and maybe it would be reasonable to infer that it's more likely you wouldn't. But you could. And secondly, this case, the affiant does not state in the affidavit, and this is different from most cases, that based on my experience, it's reasonable to infer that a drug dealer of this type would be storing things in his house or keeping records in his house. There's no statement whatsoever in the affidavit where the affiant gives his expert opinion as to why he believes that you would find, things of the drug trade, not drugs, but other things. He doesn't even mention it. There's nothing there. And I think that this court gives great deference to an expert narcotics detective who gives an opinion in the affidavit. Here, there's no opinion. So I think to some extent that without that expert opinion, the court is really speculating as to what a reasonable drug dealer or what's normal in the drug dealing business, how they conduct their business.
I mean, at the end of the day, we're talking about probable cause. We're not talking about proof beyond a reasonable doubt. And if you do have these 4 controlled buys and 2 other buys, and they're starting from the house, and yes, maybe they stop at the car sometimes on the way back, looking at the whole picture, doesn't common sense say that there is a pattern here and that the apartment is in play? I mean, I guess I just feel like you have to go to a very specific separating out things that seems to be more appropriate for a proof beyond a reasonable doubt than a common sense probable cause analysis on these facts.
Well, I'm relying on for one, I believe that of the 6 episodes, incidents, only 3 there is evidence that he left the apartment building beforehand. So of the other 3, he could have been anywhere. He could have been in his car.
But half of them, he was coming from his house. And
Yes.
we don't. Okay.
But Justice Berry does point out in her dissent that she criticizes somewhat the police work in that they, after the first controlled buy, they knew where he lived.
Right.
They could have done more surveillance, and they may have been able to resolve a lot of these issues and chose not to. With respect to the common sense, clearly this court has made clear that the mere fact that a drug dealer leaves his house and returns to his house after a drug deal isn't enough.
By itself.
In here, there's really one controlled buy where he leaves and comes back. And there may be some other evidence, but the fact is we have affirmative evidence of him using that vehicle as something. It would be consistent with storing drugs or evidence of the drug activity in his vehicle. And because of that, I think you can infer if he's taken affirmative steps to hide.
Or in the alternative, using that as a place to deposit the drugs until he takes them into his apartment. That's another way to think about it, right?
Well, I'm not sure. I would think that is consistent with someone who's storing maybe the drugs or the proceeds there and is showing by that conduct that he doesn't want things in his residence. That's highly unusual activity, and why would someone do that if he was willing to keep stuff in his house? That I think affirmative evidence that he has kept evidence out of his house. He wants to keep his house away, and he's using his vehicle to keep the incriminating evidence. He puts it in an area of his vehicle that no one would normally look. No one typically would look under the hood for evidence of drug activity. So that affirmative evidence, I think, is very important here. And again, there's really no expert opinion in the affidavit making these inferences as to the activity of this type of drug dealer, where they store, where they keep their drugs and the evidence of their drug activity.
Could we turn to the cellar or the?
Oh, my second argument is that most of the counts were based on the contraband seized in the locked basement of the apartment building. This is a multi-unit apartment building. My argument is that it's outside the curtilage of the apartment. It's not authorized by the search warrant. It is a violative of a reasonable expectation of privacy of someone. It's a constitutional search.
Now, didn't the owner of the building have access to the basement?
Yes, he did.
So the defendant couldn't have had an expectation of privacy, could he? If the owner of the building could go in there whenever he felt like it?
I think, Your Honor, it's very reasonable that if the only person with access to an area is you and your fellow roommates and the landlord, then that is reasonable. In fact, during the trial, there was, there was evidence that they stored, and actually that's not relevant on this issue, but it was a locked storage. And if there's only one other person who's a landlord, obviously a landlord can access your apartment at any point. There's a reasonable expectation of privacy. The public could not go in there. The other tenants could not access that.
What do you mean the landlord can go into your apartment at any point?
Well, I'm saying that there's an apartment. My understanding is the landlord has some limited right to go into the apartment for
if
certain reasons.
he notifies you in advance.
I don't disagree with Your Honor, but I'm saying that the mere fact that one person who you do have a contractual relationship with, has access to that, I would still think that's a expectation of privacy that society would recognize as being reasonable.
Well, what if your client were the only person to have access to the basement? Would your argument be the same?
My argument, if that access was related to his tenancy in the apartment, then I think it's within the curtilage.
Okay. Now, in this case, there was a police report that was submitted in evidence at the time of the hearing on the motion to suppress,
Yes.
and that was by agreement?
It was by the defendant, and
So the defendant offered it.
the defendant offered
Yeah,
it, yes.
and there's a statement in the police report that indicates that the landlord said that your client's brother had access to a key because he had done some landscaping business, and the landlord went on, made another statement in the report that says that the residents or the occupants, plural, not limited to your client's brother, asked for a key so that they could store a TV set, and that the landlord gave them a key so that they could store a TV set. And then there's a third sentence in there that says that the police tried the lock, but the lock had been changed. So as a practical matter, didn't your client essentially convert the basement to his exclusive use, or exclusive with his girlfriend and his brother, making it the curtilage?
Your Honor, my position is that that police report was entered.
By your client?
By my client.
Yeah.
No one objected to it.
Yeah.
It was really entered just for the purpose of showing where the location of the find was.
Well, it's in there
But
for all purposes.
And if it's in there for all purposes, I think it raises an issue. First of all, it shows it's outside the curtilage, because it shows that the access to the basement isn't contingent on the tenancy. It's based on the brother doing landscaping for the building.
No. It's based on the request by the occupants to store a TV set in the basement. They then changed the lock, which gave them exclusive possession of the basement.
I guess we read this report differently, but my reading of the report is that it first says that the brother was doing landscaping for the building and had access to the basement, and then it said the resident. So presumably, 3 persons walked up and asked for access, which I don't know if that's a reasonable inference, but presuming that my client and his brother and his girlfriend all asked for access. Still, I don't know if we can infer that my client was someone who converted the basement. I don't think there's any evidence there. But my point is, if it's
Somebody
outside,
changed the lock.
Yes, but my point is that once it's outside the warrant, and once we show that it's a seizure, the burden rests with the Commonwealth to come forward with some evidence. They didn't bring any evidence of this. And the Superior Court judge ruled that there's no evidence that the landlord objected to them the police entering the basement. That's not the standard. It's, did the Commonwealth prove
Well,
that
if
the
it's the
landlord
curtilage, if the question is curtilage, isn't that automatically included in the warrant?
Yes, if it's within the curtilage, it's within the warrant. I can see that. I see my time.
Leave it
I see
there.
my time is up.
Thank you.
Good morning. May it please the Court, Assistant District Attorney Christine Kiggin, Plymouth County, representing the Commonwealth. Your Honor, yes.
In Judge Granger's concurring opinion in the appeals court case, he notes that our case law no longer appears to provide useful precedent on this subject. So what would you recommend our precedent be?
Well, I would recommend that the precedent go back historically to look at Nexus the way that it started in cases like Sinelli, just a fact-specific inquiry as to whether there has been, in the affidavit, a sufficient nexus established between the crime and the place to be searched. I think what happened, starting with Smith, and then what happened more recently in Pena and Medina, is that a quasi-bright-line rule started to emerge. And I don't think that that's useful. I agree with Justice Granger. I don't think it is useful in a case that all these cases would be highly fact-specific. I don't think it's useful to have this bright line rule that's subject to so many different interpretations, because the way that it has come down most recently is from Pina and Medina, a single observation of a single delivery without more is insufficient. So the appeals court has been hit with so many different factual scenarios here where they are trying to determine what is without more. And even in Escalera, there was a disagreement among the panel as to without more, as to what is without more.
But isn't one of the problems that when a court asks for more and the police only make observations, at least in most of these instances of these buys, of the defendant just returning, the fact that a phone call was made requesting a drug sale could mean that the defendant's point of origin on this journey was someplace other than his apartment. How do we know that? How do we know that it wasn't that?
Because you look at the affidavit as you know, you look at the affidavit as a whole.
Yeah, I did. And phone calls were made, and nobody was at the defendant's apartment to watch him leave the apartment. So,
on one of, with the exception
and it would have
of
been
the
very
one
easy
buy.
to do, except for one control buy. Is that
Correct.
right?
Yes, on the third
Which is-
one, yes.
Which is the peanut type case. So that
Yes.
we have some information with respect to one buy. We know where the defendant began his journey, where he went to conduct the sale, and then returned. But we only know that in one of these 6 buys.
No, that's not
We
true.
know that in one of the 4 controlled buys,
The
but
4
on the
controlled
2
buys.
inferential, as I call them, drug sales,
Okay.
they have him actually leaving the rear of 449 North Main Street, getting in the car, going and doing what's very consistent with a drug deal that looked just like what he did in the confidential informant control buys. Thank you. And then returning immediately back to the apartment, inferentially, to be again in a place to accept more deliveries. So you've got 6 observations of return trips, and there's another argument here that wasn't addressed in Pina, and wasn't even addressed by the appeals court in Escalera, but it has been addressed more recently by the appeals court, and that's the whole proceeds aspect of it. And that, in this case, is absolutely distinguishable from Pina, Medina, Smith, because what you've got here are 6 observations of the defendant returning to 449 North Main Street. And I know that he went to the cars a couple of the times, and I'll address that. But it's a critical distinction, because the warrant authorized the seizure of proceeds, records, monies, accoutrements of the drug trade. Where it's probable cause and it's reasonable inferences, where is that most likely to be kept? Now, when the defendant is seen in a 10-day period, 6 separate times, returning directly to the residence after drug sales or inferential drug sales, I suggest it's an absolutely compelling inference that his proceeds are going back to the house. It's not a reasonable inference to think that he's going to leave large amounts of cash lying around in those vehicles, especially a defendant who was as concerned with security measures as the defendant was in this case. This is someone taking precautions to look around, make sure he's not being watched. This is someone using 2 different delivery cars.
We don't know a lot about the cars. We do know that there's one where he would look under the hood.
Yes.
And we have some information that he's not talking about large amounts of cash. We're talking about small amounts of cash. So based on just coming back, talking just about proceeds, money, you're really talking about money.
Correct.
$20. There's no inference that what he was doing, reasonable inference that when he comes back, what he's really doing is putting it under the hood so he doesn't bring it into the house. I mean, seems to me at least as likely as anything else. And if that's it, if it's, he just made a sale, he's going back to the house, then it's, anytime you see a sale, isn't it? There's always going to be, there's money exchange, there's always going to be proceeds. So in essence, that's the rule. As long as he's taken a $20 bill, you can go search the house because you're going to find it there.
Well, except in this case, it's not just a single sale. The other critical point here, which you didn't have in Pina or Medina, or the other cases with these single sales, this is an ongoing business. So the inference is not that there's going to be a random 20 sitting around.
You
There's
understand, yes, but I'm talking about only, you were focusing on proceeds, and it's
Yes.
enough for proceeds. You've got a lot of other things to look at here.
Yes.
And you've got return to the house, then leaving from the house.
Yes.
And you've got the inference then from leaving from the house based on our prior decisions that if he's leaving and then selling, he must have been taking it. And if it's a business, then maybe he's stashing it outside, but where is he going to package it in his car? Right. So you can make some inferences based on the decision law. But I'm just saying, if you're going to hang your hat on a return with proceeds, I don't think you can do that alone, because then forget the other rules.
And what I would suggest is it's just an important point in response to the earlier questions, an important point that hasn't really been looked at in recent times by this court. And I'm not suggesting that would save the day, and I'm not suggesting it needs to save the day in my case, or that it's going to save the day in any case. However, if it's been established, and again, that's why a bright line rule isn't so helpful, you've got to look at the contextual facts. The contextual facts here is an ongoing business. 4 short notice sales over a 10-day period. He's able to respond within 10 minutes. 2 inferential drug deals starting and ending at that apartment. He's got 2 cell phones. He uses 2 delivery vehicles. Those facts absolutely distinguish this particular case from the Pina and Medina decisions. And there's ample case law that talk about a standard pattern of a standard pattern of drug sales. And that's what we've got here. You know, this court asked for more in Pina and Medina. And what we have here is more travel. And what we have here is a standard pattern of heroin sales. And we have the proceeds. And I think that it's important to look at it all, obviously, because the affidavit is to be read as a whole. And by suggesting that there weren't more observations by the police, well, why didn't they go and sit out on the house before the sales? You're doing, I suggest, what we're not supposed to do, and that's subjecting it to a hypercritical analysis. What we have here as a whole is nexus, established by the defendant's pattern of activity in this ongoing heroin delivery service.
And what do we do about Mr. Harrington's point that there is no paragraph here, which we very often see, which says essentially, I've been a narcotics investigator for 20 years, and I know the pattern and modus operandi of drug dealers, and we don't have that here. What if any, consequence is there from its absence?
I don't think it's of any consequence to this particular case because of the facts. I would suggest that could change in a case where there weren't such compelling facts, and you may get a benefit from that kind of opinion. But what we're talking about again here is common sense. And so that for a magistrate to look at the facts presented here, 4 short notice sales over a 10-day period, and in between that, 2 additional inferential drug deals, the pattern of activity, the ability to respond on short notice, it's common sense at that point, and it's for the average person to come up with their common sense to make that reasonable inference that he's operating out of the house, that the house is his central hub of operations, not rely on solely a conclusory opinion by a detective, because we see that criticized as well. And in this particular case, we don't even need that. That would have just been one additional fact in this particular case. But otherwise, my answer is that it's not of any consequence. And what I want to respond to also was the information about the car. Justice Granger did point out that probability does not require the elimination of competing explanations. And I think that says it as succinctly as possible here. Maybe he was putting the 20, as Justice Duffley suggested, in the car when he came back, with a plan to bring it all in later. We don't know. But when the facts presented allow for a possibility of alternate explanations, the inference made here, the drugs in the house, again, it need only be reasonable and possible, not inescapable, And that was just recently stated again in Commonwealth versus Young, a nexus case, where there was some discrepancy argued as to whether he was keeping them in the house or somewhere else outside the house. And the case law says, to pass muster, an affidavit need not establish a certainty that items to be seized will be found in a specific location, nor exclude any and all possibility that items might be found elsewhere. The test is probable cause, not certainty. So I do not think that, I disagree with what Justice Berry said with respect to the drugs only being likely to be found in the car. I think that's contrary to all the facts when read as a whole in this affidavit, and I think that the case law says it can be both, again, as long as it's reasonable and probable.
What's your theory on the cellar? Do you say that is curtilage, or are you relying more on the no expectation of privacy?
I would rely more on the no expectation of privacy. I think in this case, we know that the owner, Mr. Igo, I think his name was, suggested that he keeps valuable items in there from prior tenants that he wanted to keep safe and secure. And I think in view of that, as well as in view of the fact that there were two other individuals who had access to that basement, the defendant did not have a reasonable expectation of privacy in that basement.
I mean, the two other being his brother and I don't know who the other one was.
And a girlfriend, yes. I think I saw her stated as a wife or a girlfriend. But so my argument is that he did not have a reasonable expectation of privacy in that basement.
Now, there's a reference in your brief to the landlord consenting to the search of the basement. Was there consent?
The landlord did consent to it as well, yes. So I think that
Where is that found in the record? Is that in the record?
I believe it's in the the police report that was offered at the motion to suppress, but I don't, excuse me. There's not a record site for that, Your Honor. I can try to locate one.
Okay, but you say it's in the record.
I believe it's in the record, yes.
Maybe you could address whether it is or isn't, and if so, where, in a 16L letter?
Yes, thank you.
I think in the arrest report? No, you don't want that. I do have a memory of being provided a key. I just can't remember where.
All right.
The landlord provided a key. I just can't remember.
Yes, I think I may not have the exact site in my brief, but
Didn't the police have to use a bolt cutter to get in?
To one piece of it, one part of it.
yes, and I believe that had to do with the change in the locks. I don't know for sure, but I did see that in there as well. I can address both of those issues in a 16L.
All right, thank you very much.
Thank you.